Good afternoon. Welcome to the Appellate Division, First Department. As I call the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time you've been allotted, we'll ask them, and you'll have an opportunity to answer. Over 7 hours of argument time has been requested, so we'll need to pare that down a bit. We've read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately when you start speaking. When I call your case, rise and let me know how much time you're requesting. People versus Walter Humphrey. Submitted. Bner versus Alalo.
For the appellant, we agree in 5 minutes, please.
Do you want any rebuttal time, counsel? Do you want rebuttal time? Do you want rebuttal time? No. Okay. 5 and 5. F children. Who's for the mother?
For the mother appellant, 6 minutes, please, sir.
For Amici?
Please request 5 minutes, sir.
For the twins?
The older subject children, not the younger subject children, no more than 2 minutes, sir.
Okay. How about the younger subject children? Is anyone here for the twins? Okay. So the mother will get 6, Amici get 5, and the older children get 3. Thank you. Tower National versus Lugo.
Appellant, Keith Canker, request 4 and 3. Appellant, Martinez, request 5 and 3.
Do you have a cross appeal? No.
We're joining the subject.
I see. Very good. 5 and 2 and 5 and 2. I'll give you 5. Capita Servicing versus EPAS Incorporated is submitted. People versus Deshaun Martinez. Submitted. Tang versus Beacon Broadway.
6 minutes for appellant and 3 for rebuttal. It's a prompt attack. The respondent appellant, Beacon, request 4 and 2. Respondent Skyline request 5 minutes.
Do you want any rebuttal time for Skyline? Okay, 4-2, 4-2, and 5. Browning versus DM and Associates.
Respondent request 5.
I'll give you 4, 2, and 3. People versus Kasim Williams.
Appellant requests 6 and 2.
Respondent request 4.
I'll give you 4 and 2 and 3. People versus Daniel Ruiz is submitted. 174 TIC Owner versus Nyblack.
Appellant requesting 5 and 2. Respondent requests 4.
5 and 2 and 4. DeVito versus Ye.
Appellant requests 7 and 5.
Skip one.
What's that? Give me a minute. Oh, did I miss AD family? Okay. I'll get to that in a minute. Don't worry, AD family, I took DeVito out of turn, so let's deal with them. I'll give you, appellant, you get 5 and 2 and 4. Let's go back to A&D family versus Herz. Appellant? 4 and 2 and 3. Chef Tang v. Tangy Noodle. Oh, excuse me, pardon me again. People versus Channing Parker.
For the appellant, 5 and 1.
Give you 5 and 1 and 4. Chef Tang LLC versus Tangy Noodle.
Appellate requests 5 and 2, Your Honor.
5 and 2 and 5. People versus Michael Rosa.
Calendar request 4 and 1.
Four and okay, sorry. 4 and 1 and 4. Tejada Rodriguez versus 76 11th Avenue. Do you want to be heard?
If the court has any questions, otherwise I can submit.
The court has any questions? Submission. Thank you, counsel. People versus Ernest Jones. Submitted. Swartz versus Mount Sinai Hospital is submitted. Strout versus CFE 88 LLC is submitted. Diaz versus City of New York is submitted. Bner versus Aflalo. You're up. Counsel, go to the lectern, please.
This matter, this is an appeal which has been before this court already. In August of last year, there was an order to show cause which sought to stay the administration of the estate of Alalo following a decision of Justice Gingold of the Surrogates Court of Manhattan County, which admitted a will to probate. The central question here is whether or not the court erred in dismissing the objections, dealing with the objections of the objectant, Simona Aflalo Bner, who was the decedent's son, as if they did not exist at all. What occurred was she had filed her objections during COVID in a Dropbox, which was a system they had in place and system I've dealt with myself. Those objections did not make it into the court file. Nevertheless, the court...
Now, the court did inform her that she did not timely object by the court's lights, correct?
Correct.
Did you move to vacate a default?
Did I move to vacate a default?
That's the question, yes.
I did not move to vacate a default.
Okay.
But I don't know that, Your Honor, the situation was incumbent upon the objectant to move to vacate a default. At any rate, Your Honor, the case proceeded as if the objections had been received. There were multiple 1404 examinations had in this case. There was multiple instances of the court supervision of this case, and no one, including the counsel for the proponent of the will, considered the objections not to be properly filed. Only when
So let's move on to the merits then, counsel.
only when summary judgment was filed, Judge, did the court sua sponte, on its own, deal with the
Let's
objection.
move on to the merits then, counsel, shall we?
The merits of the case?
Yes, given that the wife and the son and the attorney all authenticated his signature, why isn't that sufficient?
There's an attorney, there's an expert, handwriting expert, Your Honor, who opined and filed in the record an opinion that that will is not the will of the decedent. There is an indication in the record, Judge, that the attesting witnesses did not observe due execution of the will. There's an indication in the record, Judge, that there were notes by the attorney.
Let's stop with the expert for a moment. The expert relied on a signature on a lease, is that correct, from an
Yes, Your Honor.
Israeli property?
Yes, Your Honor.
How did he know that that signature was the correct signature of the decedent?
I believe that that was not contested, Judge. I believe that that was accepted as a valid signature of the decedent.
Huh. And did he give any testimony about what he had to do as an expert to authenticate that signature? What was...
I believe he provided a report, Judge, as an expert ordinarily will. I don't think he just filed a one-sentence summary saying, I don't think that signature's any good.
No, that's not quite the question. I mean, did he say anything about what he has to do as a graphologist to authenticate the signature on the lease?
I believe so, Judge, but honestly, I did not drill down today in preparation for this argument into the work that the expert did himself.
Please continue.
So you have a situation, Judge, where the matter should be decided on the merits. She has good arguments that the surrogate court would consider. An expert opinion is not usual in cases like this. The fact that the attesting witnesses did not indicate that they saw good and due execution, the fact that there is an indication that there was a special bequest, evidently, from the decedent in his own attorney's notes, raises issue of facts, and any surrogate's court would entertain, Judge, ordinarily. I don't think, Judge, most respectfully, and I do a lot of work in surrogate's court, that the surrogate would have dismissed the objections if he had considered them. That is
Surrogate's it's Hillary Gingold. In other words, I'm sorry, did you use the pronoun he for the surrogate?
I didn't mean to, Judge.
Okay, just checking.
I don't believe that Judge Gringold would have dismissed the objections if she had considered the merits. There's enough there, Judge, to go to a jury based on the way that they practice in that court.
Thank you.
Welcome.
If it pleases the court, I'm Mark Altschul for the respondent Alalo in favor of the will. As the court correctly pointed out, there was a default, and proper procedure should have been for vacatur, which is covered in my brief, which the respondent appellant failed to address on this appeal.
Counsel, what about your adversary's argument that the matter proceeded as though there was not a default and testimony was taken?
Well, I was under the impression that they did file everything that they were supposed to, but as the surrogate correctly pointed out, there was no filing. The answer was not verified as required under the CPA, and there was no filing fee paid. And there's no cure in any of the papers filed once the surrogate made the decision. The proper procedure should have been for a vacatur of, if appropriate, before the surrogate's court, not here.
What about the merits? Assuming we're going to overlook that procedural imperfection,
Okay.
why wasn't the evidence submitted, why was it insufficient to raise a tribal issue of fact as to due execution?
Because we had 4 witnesses that said that that was the gentleman's signature. The will is not crazy. He gives everything to his wife, who's was 83 at the time. Now she's like 86. What the other thing was, as the court was inquiring about the expert's report, the appellant in one of her statements says the signature is unusual or some word to that effect. She didn't say it's not her father's signature. And as I pointed out in my brief, and as Judge Moulton pointed out as well, the expert's opinion is not properly founded. It wasn't notarized. It was actually a translation from Hebrew, and there was no certification of the translation. So I don't think that they have established a problem with the will in and of
Counsel,
itself.
how do you handle the issue with regard to the witnesses and the indication that the witnesses didn't know that they were actually witnessing a last will and testament?
No, I think what happened was they weren't sure if they were all together in the room at the same time. They knew they were witnessing his will. They knew that this is what he wanted.
And the decedent declared that it was his last will and testament?
That testimony was very clear that way.
Okay.
I'll admit, it was foggy as to that they were all together in the room at the same time in his kitchen. If there's no other questions, I'll be seated. Thank you.
Thank you, counsel. Thank you both.
Thank you, counsel.
F children. You may proceed, counsel.
May it please the court. Will Sharon, on behalf of appellant Patrice F., who's here in the courtroom today with her husband. In Patrice's Section 1028 hearing on whether her twin babies may return home to her care, the family court in this case heard less
Counsel,
than,
place the microphone slightly closer to you. Thank you.
the family court in this case heard less than 2 hours of testimony in the first 2 months of the hearing. The hearing is now in its 8th month, and the babies have spent more than half their lives in foster care. This is without any finding of abuse and despite strong evidence that Patrice never harmed her children. In 2020, this court held that such delays violate due process. But in refusing to expedite Patrice's hearing, the family court in this case did not even consider this court's 2020 decision in the matter of FW case.
But are we, as I recall, FW, Judge Singh rested his decision, or the panel's decision there, on constitutional due process grounds. If we agree with you on the Family Court Act 1028A ground, can we rest our decision purely on the statutory issue?
You certainly could.
Although, you know, acknowledging that there are due process underpinnings of 1028.
Certainly you could. We think FW squarely decides this case on due process grounds, but we also think the statute squarely decides this case on statutory grounds. Certainly the court could exercise constitutional avoidance and decide this case under 1028, but we think FW is as clear a precedent as you can get in a case like this and has already decided it on due process grounds.
Counsel, how much of the scheduling delays had to do with the parties and their schedules and the practicality of getting a number of attorneys in court at the same time?
We recognize that those are real concerns, but we think that it stems from the family court's failure to prioritize this hearing in the first place. So in this case, the family court went about scheduling by looking at the dates it already had available, notwithstanding all of its non-emergent...
Can you just speak into the mic a little bit more? I'm sorry.
Sorry, can you hear me?
Yes, thank you.
So we believe that this case wasn't prioritized to begin with, so that the court looked at the dates it already had available, that it didn't have any other hearings at all or any other hearing time, and then it asked the parties, are you also available on those dates? It struck any dates that any attorney said they couldn't appear, and then it asked the attorneys on top of that to ask their experts for the dates that they would be available. And any dates that the experts didn't provide, the court also struck from its calendar. So because the court failed to prioritize this case, even as necessary over its non-emergency docket.
Counsel, how practical is it that a couple of, not Ms. Chin, but a couple of the other lawyers were from institutional providers? How practical is it in these types of cases to, substitute another lawyer from the same institutional provider?
We think it's practical, and it does happen, especially in a case like this where from the outset, so the 1028 in this case was filed at the very beginning of the case, before people had become familiar with the record and before people had become as familiar with the circumstances. At that point, it would have been feasible, but we're not suggesting that the family court needed to require attorneys to find coverage for each case. Or for each hearing. That was just one of the many means we think that the family court could have used if necessary to further expedite the hearing. But I think the bigger issue in this hearing is that the family court simply didn't prioritize it in the first place. So it looked at its calendar to see what days it didn't have other hearings, but that included all of its non-emergency docket. This is a Section 1028 hearing, which this court emphasized in FW warrants priority over these other cases.
Sir, did the parties agree, as the family court judge suggested in her decision, that did the parties agree that there should be a combined 1028/fact-finding hearing?
The parties didn't dispute that the family court could use the evidence from the Section 1028 hearing in analyzing the fact-finding as a matter of the actual fact-finding process. But the reason for that was pure efficiency. So rather than requiring an expert witness to say, come back again and testify later in the fact-finding, the parties were okay with and didn't object to the court using the evidence from the 1028 to the extent it met the evidentiary standard for the fact-finding hearing, also in the fact-finding.
Is it your position that a decision on the 1028 should come before a decision on the fact-finding, regardless of whatever overlap the evidence may prove to have, that a determination of the 1028 should come first and that it shouldn't be sort of a joint or consolidated decision on both matters?
We don't object to the combination, so to speak, in an abstract sense, and certainly the court could issue a decision on the fact-finding as soon as it issues a decision on the 1028, if enough evidence is before the court at that point. We think in a case like this, where the court recognizes that there's a lot of overlapping evidence, that very well may happen, but because the 1028 needs to be prioritized, the court has to hold this schedule this hearing on the 10/28
Counsel,
schedule.
in terms, I'm sorry to interrupt you, but in terms of your argument regarding prioritizing, what does that look like if not looking at all of the lawyers' schedules and coming up with dates that work for everyone?
I think what it looks like is the court first, instead of looking at its own schedule and trying to fit hearing time in where it has half an hour here and another 45 minutes in 2 weeks, it requires the court to make time. And sometimes that might mean prioritizing this hearing over a fact finding that doesn't have a 1028 component, or over a custody matter, or something that doesn't.
So it looks like trumping other cases that might already be on the calendar,
We
given
think-
the nature of those cases?
We think that's one of the methods. There are certainly others. So as Amiki pointed out, and as we point out in our brief, the court can also do other things, like as necessary, subpoena witnesses. It can require attorneys to appear because, I see my time is up, Your Honor. May I finish answering your question?
Any other questions? Thank you, counsel.
Thank you.
I think I'll take the attorney for the child first before the amici. Please, Ms. Shin, you're up.
May it please the court, Justice Moulton. My name is Donna Chin, and I represent the older subject children who are now 16 years old and 9 years old. As I've stated in my brief, my clients are articulate, they're intelligent, mature, and poised, well-mannered, and they have age-appropriate understandings of the issue before this court. The older subject children asked me to come today before Your Honors to express to Your Honors the unfairness, their word, and then my words, of protracted piecemeal litigation that has so affected their family. Their words, so I wish to read, and their wish to spend more time with the twins at home, with my younger child client expressing that she would like the twins home as soon as possible. The AFC below also wishes to express to this court the fact that time is different for children than for adults, and he just expresses that the children have been in care for approximately 10 months, which would be 1/10 of the younger subject, my younger client, and that would be the equivalent of 5 years for a 50-year-old.
Your clients were returned to the
Yes.
mother rather quickly. How much time were they away from
It
the
was in
family?
my brief, Your Honor. I believe they were returned the 21st, and my recollection of when they were removed is not, I could refer to my brief, Your Honor.
It's
but
not necessary.
It was not, it was less than a week, I believe.
Counsel, from your standpoint, how much of the scheduling delay has to do with the lawyers' schedules as well?
Your Honor, I have to be honest that when I read the Legal Aid Society brief, it did occur to me that family court, as appropriately pointed out by Amici, had many tools at its disposal. In the olden days, when I was at Legal Aid Society, I would imagine that the judge would have called my supervisor down within 5 minutes had I said that there was no other attorney at the Legal Aid Society who could step in. I'm being quite honest with this court right now, perhaps overly honest.
Counsel, didn't you go into overtime? Wasn't overtime something that was routinely permitted?
Yes, and just imagine, in terms of the olden days when I was at Legal Aid Society, saying that you couldn't have an arraignment within a certain amount of time because, you know, at the court's discretion, they didn't have enough time. Well, we made time, right? We got night court and lobster shift, but
So it sounds like everyone's saying that the judges ought to drill down a little bit more on the lawyers to make sure that they make time and make it a priority.
the AFC below offered up a substitute, and we as solo practitioners do have substitute AFCs, and we have used them. I'm going to speak for him. But the Legal Aid Society, I'm not familiar with not having someone who could come up to speed, as this court has done very quickly and as we have done, and who could not second seat or substitute in for 2 weeks, for example, for a vacation. But I do agree with Amici and rely upon their argument that there are plenty tools that court could have utilized.
Thank you.
Thank you.
May it May it please the court, David Chalakline, Family Justice Law Center, on behalf of Amici, Advocates for Children and Families. Amici represent thousands of children and parents, and we speak today with a unified voice to stress the urgency of family courts completing emergency family separation hearings promptly. It is well known in family court that depending on what part you draw on intake determines whether you will get an emergency family separation hearing held in 3 days or 3 months. That arbitrary and inconsistent administration of justice must be changed.
Why is that?
Judge, there are some family courts that when they have an emergency family separation hearing in front of them, say this has to be done promptly. Attorneys must be here, witnesses must be here. Is there any need to get any type of elusive evidence or experts here? If the evidence is ready to be heard, you will be here. And some family courts do that and do that well. And I cited one example in the brief of one family court in Bronx Family Court who had almost an identical case to the one at Bar. And it held that hearing, one of the most complex and high-stake cases, in 2 days and determined that the children were safe to go home to their parents. Those children in that case spent 2 days away from their family because the court held it promptly. In this case, the parents have been separated from their young twins for 7 months for no difference other than, Your Honor, as you said, if an attorney says, I have something else, the judge's question should be why? What is it? Is it another emergency family separation hearing? If not, you better be here.
So if what I'm hearing you say is that it depends on the judge that the parties draw. Is that what you're saying?
Judge, what we see as amici, who've been in family court for decades, is that very much depending on who the court is, what the judge is, and whether they are actually utilizing the vast and varying tools that we've talked about, that trial courts know how to move cases forward and believe that good cause is actually a real standard that's not just court and attorney conflicts, that it has to be tied to some type of elusive evidence or something to a correct adjudication on the merits. They make cases go and complete promptly.
Counsel, are we talking about parts with analogous caseloads?
Absolutely, Judge. Absolutely. This is based on attorneys for children and attorneys for parents who are across the boroughs in New York City and who have seen family courts, different types of family courts, over decades, really. And it's not to say that every judge has to do it in the exact same way, right? The discretion that a trial court has is not whether they can follow the law, right? It's not whether they can follow the plain language of the statute or the constitutional principles that are embedded in it. But of course, they have discretion within that to determine how to juggle their calendar and all the different balls that family court has in the air. But the golden ball, the entire statutory scheme that the family court is about is protecting children, but also making sure that the system itself is not unnecessarily inflicting unnecessary harm.
Counsel, in your brief, several times you say that thousands of children have been the subject of extended hearings. Is there data on that? And of course, this is court system data that perhaps we should be compiling ourselves. But do you have data that backs up that statement?
Yes, in the brief, we cite to a letter that was sent to the chief judge that we include data, which was from an information request from to OCA, and that's where that data comes from. It also just comes from our experience. And
the data that, just to return to the data, it's more of an inference, isn't it? That you know how many hearings have been held since 2014, and you presume, given on the number of hearings that have been heard pursuant to 1028, that's X amount have been prolonged unnecessarily.
There is a little bit of an inferential jump in there, I will agree with Your Honor, because OCA does not keep data on how long does it take from start to hearing to finish of these hearings, and that's actually something we've been pressing to OCA. But from our experience, and we represent virtually all parents and children across the city, we know that these are not regularly being completed in 3 days.
Counsel, just another question about the experts here. Are the experts that are in this case outside of the realm of other types of experts? Is it some sort of something specialized that we're having issues getting those experts in?
There are two answers to that question. The first answer is the case that this court has in front of it is not the garden variety 1028, right? It is a very complex medical case. And the vast majority of 1028 hearings are really ones that are much more straightforward, that will take many fewer hours. But when a family court does have a complex case like this, it is pretty much in the realm of what these medically complex cases are. I think we cited 3 of them in our brief, and to show that they can be done quickly. So the number of attorneys, the number of experts, the amount of documentary evidence, these are all things that family courts should and can, with what they have now, complete promptly. The problem here is just that the court did not use an affirmative duty to push this case forward.
So in your experience, is it uncommon for a 1028 to be coupled with the fact finding?
Again, Judge, I'm going to sort of give 2 answers to that because the case that you have in front of you now, the inquiry on the 1028 is so identical to the inquiry on the fact finding that sometimes they get combined. As one counsel said, for judicial efficiency, it would make no sense, right, to have one expert give the same testimony twice. But the vast majority of 1028s are not combined with fact findings because the inquiries are so separate. One, almost primarily, the 1028 is a prospective looking inquiry into, is the child at imminent risk in the future based on changed circumstances, new things, while a fact finding is completely retrospective and has the government met its burden based on the allegations in the petition.
Any further questions? Thank you all.
Thank you, Your Honor.
Tower National versus Lugo. Please.
Good afternoon, Your Honors. May it please the Court, Michael Kazoras from the Law Office of Eric D. Feldman on behalf of the defendant appellant Keith Kankar. We believe that Justices Bluth's order in the prior action and this department's prior decision in this very action has preclusive effect on the plaintiff's claims against the tenant Keith Kankar. Back in the action where One World sued only Mr. Lugo moved for summary judgment, and Justice Bluth wrote, the fact is that there was a leak.
I don't know about this preclusive argument that you're making. I'm not sure I dwell on it, although my colleagues may have questions. But it seems to me that the duties of a tenant are going to be different than the duties of Mr. Lugo, who's the owner, and therefore there would be no claim preclusion here.
Well, Your Honors, under the proprietary lease and the sublease, all of the maintenance obligations always remained with Lugo. And I can quote to you the sections of that, and including Justice Bluth said that that Mr. Lugo nor the tenants had any notice of it. But in paragraph 4 of the sublease said that the sublease is subject to and subordinate to the proprietary lease. Paragraph 15 of the proprietary lease says that no consent to subletting shall operate to release the lessee, meaning Mr. Lugo, from any obligations hereunder. Paragraph 10 of the sublease provided that Mr. Kankar cannot build in, add to, change, alter the apartment in any way. Paragraph 13D of the sublease provided that appliances supplied by Mr. Lugo in the apartment were for the tenant's use and their good working order and will be maintained and repaired by the owner. And that was the course of practice that landlord and tenant had.
Those arguments, it seems to me, have another, for you, good effect, which is it seems to me it also means that there's no exclusive control for res ipsa purposes.
I agree, and I think that to some degree those issues overlap because I think that Justice Bluth considered that in her earlier decision when she found that neither Mr. Lugo as the landlord nor his tenants had any prior notice of this condition. And this very court affirmed actually reversed the denial of Mr. Lugo and Mr. Larson's motion for summary judgment in this case, finding that there was preclusive effect. And I think it's significant that to the extent that the respondent argues, well, Keith Kankar wasn't a party to the prior action. Well, neither was Mr. Larson a party to the prior action. And yet this court found...
But what was Mr. Larson's status? He was a licensee, or he was the...
He's the husband of Mr. Lugo.
So...
And he was not a defendant
more analogous
in
than...
prior...
I would say more analogous to Mr. Lugo than your client or Mr. Martinez, but anyway.
Anyway, Your Honor, moving on from that issue, even if the preclusive effect argument is not persuasive to Your Honors, Mr. Kankar and Mr. Martinez, for that matter, established a prima facie case before Justice Getz that they didn't create the condition and had no actual or constructive notice of it. They submitted affidavits that there was absolutely no problem with the sink until this sudden and catastrophic event. You know, that was according to their course in practice, was to notify Mr. Lugo of any problems that they had in the apartment, any issue of maintenance, repair, they brought to Mr. Lugo's attention, and Mr. Lugo took care of it. The sink was never an issue. Neither Mr. Lugo, Mr. Larson, Mr. Kankar, nor
Is it the sink or the piping underneath the sink the issue?
I'm sorry, Your Honor?
Is it the sink or the piping, the water pipes under the sink?
Well, it's the water piping under the sink, but that sink and those water pipes were put in by Mr. Lugo's contractor in 2011, several years before Mr. Kankar and Mr. Martinez even moved into the apartment as tenants.
Were any repairs made to those pipes that were under the sink between the time that they were put in by Mr. Lugo's?
Absolutely not, Your Honor. And there's been deposition testimony and affidavits from Mr. Kankar and from Mr. Martinez to that effect.
Thank you, counsel. You have time in rebuttal.
Thank you.
May it please the court. I represent Abby Martinez. Abby Martinez is the partner of Keith Kankar. I want to remind the court that Abby Martinez was not a tenant on the lease. Abby was a permitted occupant in the apartment. So his status is entirely different than Mr. Kankar's. I would argue that he's removed one step from privity and from duty to neighboring property owners. I want to go back to a question that Your Honor raised about the preclusive effect. If you look at the decision from Judge Bluth, it's clear that what the judge was saying was, I'm going to make this decision regardless of who is in control of the property. Control really wasn't at issue. What Her Honor was saying was, because this was a latent defect, there's no way whether or not the owner or the occupant could have done anything here because it was a latent defect. And therefore, we're not going to impose a duty here that would extend to compelling an occupant of the apartment to somehow, or an owner of the apartment, to somehow discover a problem that was underneath a cabinet that nobody had any reason to believe was a problem. So control wasn't a part of that decision. I think that was the question that was asked, which is there a difference here between the owner and people who are residing in the apartment? And my colleague is absolutely correct that the decision was extended by the appellate division, not just to Mr. Larson on appeal in this case, but also to Mr. Lugo. So Mr. Lugo was the husband of Mr. Larson. Neither one was a tenant. Neither.
I think you got the names slightly mixed up, but I know what you mean.
I'm sorry. It was extended to Mr. Larson,
We know
not
what you
Mr.
mean.
Lugo. But I want to, my colleague has already addressed the issue of control that was dealt with in the lease. As a legal matter, Mr. Martinez had absolutely no control, he had no right to actually do anything with respect to the plumbing in the apartment. So even if he had some sort of x-ray vision and could have determined that there was a problem, it would have been his duty to notify the owner, and then the owner would have taken action. When he saw that there was leaking water in the apartment, he immediately notified the super. There's nothing else he could have done. Our position is that the duty here can only go so far as the control that one has. And he had no legal control, and he had no actual control over knowing what was, in fact, a latent defect. To impose liability on Mr. Martinez here would, in effect, be to create strict liability. That's not a claim in this case, and I don't think there's any basis for that. The analogy here would be an adult child who's living in the apartment somehow has liability to an adjoining property owner because water is, unbeknownst to him, leaking from a faulty pipe in the apartment. Mr. Martinez is not on the lease and had no duty here to discover a latent defect.
Thank you, counsel. You have time in rebuttal.
May it please the court. My name is Kevin Fitzpatrick, and I represent the respondent, Tower National Insurance Company. First, I'd like to touch on the statement that there was a latent defect. This was a motion for summary judgment, and there was no evidence of that it was a latent defect, just that it was a pipe burst. There was no evidence that
But there was no evidence of any notice with any defect with respect to the sink in any way.
But there was also no notice of any inspections either. They had exclusive control of the apartment, and nobody could gain access to that apartment without their permission. They had a duty to alert the landlord if there was an issue, or the building.
It sounds to me like you're articulating a duty that nobody in this room would ever adhere to. You know, I don't look under my sink to see if the pipe is working or not. You know, God forbid, but someday maybe it'll break. But it's not. I don't think it's a duty that someone residing in an apartment has to get into the plumbing in such a.
Well, with a co-op or a condo, you're responsible for the pipes within the walls of your apartment. Since those pipes are within the walls, you are responsible for them. So you do have a duty, whether you undertake it or not, is not the issue. But you do have a duty to look at those pipes. No different than I have a duty to look at the pipes under my sink. If I choose not to and they leak, I'm going to have to pay to fix the damage.
Was the cause the installation of the pipes? Was that the cause?
There's no evidence of that. It's just that the pipe burst. They stated that there was a potential improper valve. There's no evidence of that in the record. So we said even if we adopted that, since they accepted the apartment as is, they would be accepting the apartment with whatever defects there are. And I think you can argue that any time a pipe leaks, there is some negligence somewhere. And it was their duty to monitor to at least monitor all the pipes inside their apartment.
Anytime a pipe leaks, there's negligence?
That's what this court is.
Articulation of the law?
That's what this court has held. Okay. It's in my brief. This court has held that a pipe does not necessarily burst without some negligence.
But isn't it the owner who's actually responsible?
The owner would be responsible to fix the leak, but the owner is not responsible to identify the leak. This court held, and so did Justice Bluth, that the owner lacked the ability to because they lacked exclusive control. The tenants here had exclusive control. Both Mr. Kankar and Mr. Martinez signed the agreement with the co-op board that they would adhere to it and they would be responsible for the
lease that they had with the owner puts the onus on the owner to make those repairs.
To make the repairs, correct. But they had a duty to identify the repairs. They had a duty to monitor them. So if it's no different than I have no ability to fix the pipes under my sink, but I have a duty to monitor them. If I see that there's a leak, I have to call a plumber. If they saw a leak, they were supposed to call the owner. They never inspected the pipes. Under their own testimony, there was no inspection. There was no repairs ever done to the pipes, and the pipe just leaked.
Is there any indication that it was some ongoing leak that they never called about, or was this not something that happened sort of in an emergency.
They never looked, so we don't know if it leaked before or not.
I want to push back a little bit on exclusive control for res ipsa. I mean, didn't Mr. Lugo retain a great deal of power with respect to maintenance of the apartment?
Mr. Lugo said, if there's something wrong with the apartment, let me know and I'll get it fixed.
No, he has a duty under the sublease, doesn't he? And under the main lease, actually, which is incorporated in the sublease.
Well, they actually both had a duty under the agreement with the co-op.
But how is that, explain to me how it's exclusive control between these two subtenants?
Because Mr. Lugo and Mr. Larson did not have access to the apartment at all. They would never know if a repair was needed to be made. There was no way for them to ever identify that a pipe was leaking. So the exclusive control was with them, with the tenants, to identify the problem.
But didn't the sublease preclude them from making any alterations?
Alterations, but not emergency repairs. This was an alteration. They weren't putting in a dishwasher. This was a repair. And I would again disagree with Your Honor. I think that exclusive control here goes with who had control of the pipes. They had control of the pipes. They could only get them fixed if they asked. If they didn't ask to get the pipes fixed, they could never get fixed.
Thank you, counsel.
Your Honors, there was no reason to fix the pipes that were working perfectly fine. This was a sudden and emergent condition that the tenants brought to the attention of the building and to Mr. Lugo immediately upon it happening. As Justice Bluth indicated in her early decision, that was not appealed by One World, that there's no duty to inspect a sink that's working perfectly fine. Is this court prepared to create a duty to inspect pipes in everyone's home and apartment just to see if there's something wrong with them when there's no other indication that they're leaking or that there's a problem? And with regard to the exclusive control issue, Mr. Kankar and Mr. Martinez didn't have control over this apartment when the alleged defective ball valve was installed years prior by Mr. Lugo's contractor. That's a large focus of the respondent's brief. They are relying on this defective ball valve that caused this leak. This ball valve was installed years before the apartment was even leased to Mr. Kankar. So he certainly didn't have exclusive control over this apartment at all relevant times. And that's what's required on an argument for res ipsa loquitur. If Your Honors have no further questions, I rest on the brief.
Thank you, counsel.
Thank you. I just wanted to clarify a couple points on information that's in the record. Mr. Martinez testified that when he first occupied the apartment, he did do a visual inspection. He noticed, in fact, that there was some glass that was broken. So he went about, I mean, to go back to the issue of control, he did what he could. He acted with, the control that he had, meaning he inspected the apartment, noticed some things, and brought them to the attention of the lessors. The other point I wanted to raise.
What follows from that, though, counsel? That sounds like it supports
What follows from that is that he did all that he could do. None of us walk around with an X-ray vision machine that they can see through.
Are you conceding that that's exclusive control then? No.
Not at all.
I misunderstood.
No, not at all. Not at all. I'm saying that I think control and duty go hand in hand, and you can't have a duty where you can't foreseeably expect that there's going to be an issue, right? So his duty extends to that which he has control over. If he sees that there's a broken window, okay, that's within his zone of control. He notifies the landlord. It's the landlord's responsibility. On the issue of the pipe, the question was raised: is it really true to say that a pipe can burst only as a result of negligence? It's sort of silly. I mean, pipes wear, and pipes don't have a limitless lifetime. They have a lifetime of usage. And so to say that every pipe that bursts, that there is a res ipsa loquitur claim is silly. That's essentially what respondent is arguing. That if there is a pipe that bursts, that somebody's responsible for that, that there's a res ipsa loquitur claim. But that's silly. It's silly on top of the fact that here, essentially respondent has conceded that evidence was introduced demonstrating that in fact it was not the tenants who were responsible for the damage to the pipe, but it was the contractor.
Thank you. We have your brief. Thank you all. Tang versus Beacon Broadway. Please.
May it please the court, my name is Victor Serby, and I am going to be arguing on behalf of Appellants Tang. This is a Labor Law 241 case, and
You also asserted 241 sub 6 claim. I just want to see if we can put that one aside, because there is no industrial code section that is cited to undergird that claim, correct?
that is correct. I think we could set that aside for now.
Very good. Thank you.
Notice they didn't really brief that. In any event, this court in Phillips and Iona, under identical circumstances, where a worker was working on a erecting scaffolding for a sidewalk bridge, fell off the truck and injured themselves in basically the same
See, in those cases, though, the plaintiffs were standing on a great deal of material on a platform truck. How many 2 inches by 4 inch pieces of wood was your client standing on? And what does the record show about that? If you can cite us chapter and verse about that.
It was a few feet. He testified he was standing on either 2x4s or 4x4s. Basically, they were stacked up. And
you estimate 3 feet in your brief, and I was wondering what the record evidence for that would be.
Nobody actually stated the height, but it's a distinction without any importance, in my opinion, legally.
Counsel, can I draw your attention to page 304 of the record, wherein Mr. Tang is asked about the level of the 2x4, basically how high they were, and he's asked at line 15. Now, the one level of 2x4 that you were standing on, about how many inches did that bring the bottom of your foot from the flatbed surface of the truck? And his answer, not feet, his answer on 19, a couple of inches. And then the question again, when you say a couple, what do you mean? Do you mean 2 inches? Do you mean 5 inches? What do you mean? His answer, 5 inches. Let's say 5 inches.
Okay.
So he's not talking about feet. He's talking about a few inches from the bed of the truck.
Okay. Nonetheless, the truck is about 4 feet high. That's his feet was another few inches, and the actual injured shoulder. He's 6'3", and
So you're counting into the elevation his height?
yes, because
That's supported by the case law?
What?
Is that supported by the case law?
didn't find anything with respect to the case law, with respect to the height of the fall. But nonetheless, it is an elevation-related injury. He would have started out, he had his harness with him. He did not have a place to hook in. And if he were hooked in, as he's passing these planks, the truck is all the way.
But this accident didn't happen as he was passing planks and doing his work. He had finished his work and was passing a cup of soda to a coworker.
It was still part of his work. It wouldn't have mattered if he passed the soda. And if somebody on the bridge asked for the soda because they were thirsty after a hot summer's
But
day.
he had finished passing all of the planks that were a part of his assignment.
Nonetheless,
no more left.
he was still at work on the top of the truck.
No, I just wanted to know that part of it.
Yeah, that part
He had
of it.
completed that part of the job.
He testified that he finished passing the planks, but that was not part of the work. He was still on top of the truck. He did not. He was not in the process of alighting from the truck. Going down. He was still on the truck. Somebody asked him for a soda, and he got up on some 4x4s or 2x4s.
Thank you, counsel.
May it please the court, Glenn Kaminsky with Morrow Lilling, the party counsel for the Beacon respondent appellants. And I ask this court respectfully to modify the decision of the Supreme Court so as to deny Skyline's motion as to contractual indemnity and grant the motion by the Beacon defendants. Otherwise, we ask it affirm. This case is not a 240 case. Plaintiff is, Your Honor has already pointed out, he says he's maybe 5 inches above. His testimony is that he's standing on one level of 2x4s that are only there for the purposes of getting the forklifts under the planks that were already removed. The planks were removed. He was done with his job.
Well, let's turn to the contractual indemnity claim then.
I would love to. Thank you, Your Honor.
Why should Beacon be the beneficiary of that provision as opposed to Beakway? I can see Beakway, but I'm not sure about Beacon.
Okay. I would look to the testimony of Mr. Travers, okay? Mr. Travers testifies that Beacon is the parent company of Beakway, that Beacon owns Beakway, and that they share the same members. And then I would look at the contract record 111, where the obligation to procure insurance goes to the benefit of Beacon as well. Based upon that, it looks to me like you have an agent for disclosed principle, Beakway being the agent.
Where in the record 111 says that the obligation to, that somehow indemnification also runs to Beacon?
The indemnification, 111 says that the additional insured requirement runs to Beacon.
Right.
So that just shows that they know how to name Beacon separately when they want to. That's another inference we can draw from that,
Your Honor.
Yeah.
Did they do that when they entered into this contract? Did they name Beacon as a party to the contract?
You could not see that in either 3.18.1 or Exhibit A clause. No, Your Honor. So as to Beakway, and it makes no really substantive difference because it's really going to be about the defense costs, and they're going to be the same defense costs. Beakway is going to be entitled to indemnity because both clauses are in play. There's no reason for what's happening here. Skyline says, well, you know, we moved under 3.18.1 below, but now we want to say it's Exhibit A, and they conflict. But they don't conflict. They differ. And having differing language does not ipso facto make them a conflicting clause. Matter of fact, you can clearly read both of these broad indemnity clauses and apply them. And how we apply them here is that we see that there's claims of plaintiff's own negligence. And in fact, Skyline, in their own papers, when they incorporate the procedural history of Beacon's motion, they incorporate their own answer. 178 of the record shows that in their answer, they assert an affirmative defense of the plaintiff's own negligence. And then what we see is that Skyline included plaintiff's full deposition transcript. So we have then the facts of the accident right there, and the only parties that could be at fault here that are actually negligent or alleged to be negligent, the language of the hold harmless agreement, is Metropolitan Northeast, the employer, or the plaintiff. And if it's plaintiff, guess what? His negligence is imputed to the employer.
Thank you very much, counsel.
May it please the court, Gerald Ford for respondents.
Mr. Ford, would you pick up on that thread about whether the two indemnification provisions do conflict?
I think they do.
I got to tell you, I don't see it, but so convince me I'm wrong.
Okay, well, the 318 one refers to negligence. Negligence is the trigger for the clause, refers to, includes an employee of any of the subcontractors. Exhibit A does not say that. So that's a significant difference, and I think it's fair to say that they conflict in that respect. I think ultimately, Your Honors, the key question, first of all, I'm going to rest on my brief with respect to the 240 claim. On the contractual indemnity claim, I do think the easiest way to resolve this is regardless of whether 318.1 applies or Exhibit A applies, the question is, was Metropolitan, plaintiff's employer, negligent? And there was just no evidence produced below that it was negligent.
If plaintiff is negligent, isn't that enough? If the plaintiff himself was negligent? Isn't there at least an issue of triable fact about that, which would lead to a conditional order of indemnification?
Well, first of all, if Exhibit A applies, the plaintiff's negligence is not a factor for the reasons I expressed in my answer to your first question. If plaintiff, in fact, was negligent, could it be imputed to his employer? Yeah, possibly. But here again, there's no evidence that the plaintiff was negligent. The lower court made no finding that the plaintiff was negligent. It's not like the lower court said, oh, sole proximate cause of the plaintiff was the accident. No, the lower court said this just isn't a 240 case. It's not a sufficient elevation risk.
Right, but it also got rid of common law negligence in Labor Law 200. Does that cut any way?
I don't think so, Your Honor, because that related to common law negligence of the owner, and there's no question, of Beakway, rather, and there's no question that they were not negligent. But the Beakway seems to say, well, because there was an accident, plaintiff's employer must have been negligent, and that's just not the case. They didn't produce any evidence of negligence by Metropolitan. There's no expert report that said Beakway was negligent. So I think the lower court got it right. If the court has any other questions, I'll be happy to answer them.
Thank you, counsel.
Okay.
I just want to address the issue of negligence. The issue of negligence is between the third-party defendant and the defendant in terms of their indemnification agreements with respect to Labor Law 241. Court of Appeals precedent, Rokovich versus Consolidated Edison, 78 New York 2nd, 509, 513. The court clearly says that we've interpreted this section as imposing an absolute liability for breach which has proximately caused the injury. Negligence of any of the injured workers is of no consequence. And then they had string cite. So with respect to Mr. Tang, whether he was not negligent, but whether there was no finding of negligence, but the accident did happen. He did suffer a fall, which of the statute, the Court of Appeals goes on in this section to talk about exactly what the statute is for, and it's to be construed liberally as may be for the accomplishment for the purpose of which it's created, and protecting workers against falls is the primary purpose or the original purpose of the statute. Things came in later, that stock exchange case where somebody had a very large roll of copper that they were wheeling through the
runner, yeah.
Stock exchange, and the courts have been adding to that in tradition in accordance with the liberal construction of the statute to protect workers, and that's the utmost importance. So with that, unless the court has any questions.
Thank you very much, counsel.
Thank you, Your Honor.
Please.
I believe that the record amply demonstrates potential negligence of the plaintiff in Metro Northeast, but at a minimum, a conditional order of indemnity would be appropriate. And I will note that the lower court didn't even address that as a possibility at page 15 of the decision. The court noted that no employees of Skyline or its subcontractor being Spring Scaffold were present at the job site and no employees of Skyline exercise supervision and control. But that's not the question for both of these indemnity clauses. Is one of the can a subcontractor be negligent? The answer here is yes. Metro can be negligent by virtue of the plaintiff's own negligence. Negligence that is actually alleged by Skyline, implicating the indemnity clause. First, I would say that is sufficient in and of itself to grant us indemnity, but even if it's not, conditional order of indemnity should be granted. And unless this court has any other questions, I'll respectfully rest on our brief.
Thank you very much, counsel. Thank all of you. Thanks to all of you. Browning versus DM Tellock and Associates. Please.
Good afternoon. May it please the court. My name is Lamar Moore on behalf of Appellant DMT. As the court is aware, this appeal concerns the lower court's decision to confirm an arbitration award, and we believe that decision was erroneous for some important reasons. First and foremost, because the lower court applied the CPLR rather than the FAA in rendering its
Yeah, I'm going to ask your opponent that, but it does seem that they concede that the FAA applies, but I'll ask that question.
I was actually just getting to that point. It's not disputed by my opponent, or at least not explicitly disputed, that the FAA applies and that this underlying contract implicates interstate commerce.
That's the FAA still allows only limited review of arbitration decisions. There's extreme deference, quote unquote, to arbitrators under the FAA, correct?
Yes, that's correct. That's correct. And that would be my next point, getting into the manifest disregard of the law standard itself. But I do think it's important that the court applied the CPLR rather than the FAA, particularly given in 2006 that for that very same mistake, a decision from, I believe it was the First Department, was remanded by the U.S. Supreme Court. I think that was Wine Malkin LLP v. Hemsley Spear, which is cited in our brief, where a decision regarding an arbitrator award was remanded in light of the U.S. Supreme Court's Citizens Bank decision. In that decision, we had the same error. The CPLR was applied rather than the FAA, given that the contract underlying the dispute implicated interstate commerce. So that same error is made here, and that same error is a basis, just as it was in that case, for reversal of the lower court's decision.
Did the arbitrator manifestly disregard the law in this?
Yes. And so even if we do get into the substantive analysis, applying federal standards, there is a parallel manifest disregard of the law standard in New York, which was inapplicable. But even applying the federal standard, which the lower court did not do, we still think that this award should have been overturned. Really quickly, the decision was barely explained. There was almost no explanation at all. The arbitrator essentially said, you know what, both sides either breached or were unjustly enriched, right? Taking even just that sparse statement alone, I think almost anyone knows basic contract laws, you can't have an unjust enrichment claim where there's undoubtedly an express written agreement, right? And so just that instance by itself shows that, all right, the arbitrator did not apply a black letter legal principle to this case that was clearly in front of him. And beyond that, there's almost no explanation whatsoever for the award. I think we will concede that this is a rarely applied standard, the manifest disregard of the law standard, but it is more likely that we do have that applicability in those instances where the arbitrator gives no reasoning whatsoever, and that's cited in our brief as well, that it's more likely that we have a instance of manifest disregard where the arbitrator failed to give any written explanation.
The arbitrator says that both parties breached the contract.
The arbitrator says both parties either breached the contract or were unjustly enriched. The contract underlying this dispute was essentially a fee-sharing arrangement between a California-based attorney and a New York-based firm
It's not disputed that one party didn't get paid for a certain period of time of work, right?
It is not disputed that one party did not get. Are you saying Browning did not get paid?
Yes, it's undisputed that she wasn't paid for a certain period of time for.
So the dispute itself revolves around invoices for work performed in a period between August 2021 and December 2021. From the period of August to, I believe, October, Browning says that she wasn't given her percentage of fees that should have been split between the parties. And then between November and December, DMT was not given its percentage of that fee arrangement that should have been split. And so,
Thank you, counsel. You have time in rebuttal as well.
Good afternoon, Your Honors. May it please the Court, Robert Lash for the respondent. Let me address the first question on the applicable standard, CPLR or FAA. Essentially, we cited cases in our brief. The standard is essentially the same. The courts have ruled it's effectively the same, but we're willing to concede to speed this up. FAA applies. Fine. Manifest disregard. There was no manifest disregard here. The arbitrator got it right. And as the court was saying, between August and December of 2021, Ms. Browning worked in August, September, and October hundreds of hours, generating over $100,000 in legal fees, and she incurred out of her own pocket over $32,000 in expenses, court filing fees, deposition costs, FedEx fees, that she paid herself. She submitted all that to DMT. DMT submitted it to Wells Fargo, was paid for all that by Wells Fargo with the understanding that they would then pay it over to her, and they didn't. Then in November, DMT and Ms. Browning were informed by Wells Fargo that Wells Fargo decided to terminate its relationship with DMT and that it was going to reassign the cases that it had previously assigned to DMT. And it was conceded, undisputed, that once the cases were reassigned, which for the Browning cases was around mid-December of 2021, that DMT could no longer access those files or submit any bills for those cases, even if DMT could submit invoices for other cases it was working on. Once a case was reassigned, it was locked out.
Didn't she notify DMT that she was terminating the agreement in November?
She said in November, when she heard from Wells Fargo, she said, I'm going to continue to work on these cases for DMT until they're reassigned, because then DMT can't do it anymore. And DMT, and this is an important point, DMT received, we're talking about the August, September, October fees and expenses that DMT withheld from her. DMT got paid. We submitted evidence to the arbitrator that DMT was paid for at least some, if not all of that, before she gave that termination notice. So if anybody breached an agreement here, it was DMT who breached first.
Well, let's talk about the arbitrator's decision. Did the arbitrator provide a barely colorable reason for the decision?
The arbitrator asked the parties, do you want a reasoned decision? Both parties said that's not necessary. So he gave us what he gave us. If you look at the numbers and you look at the papers, what he did was exactly August, September, October, what DMT was supposed to pay Ms. Browning, he said that should be given to Ms. Browning. The November, December that Ms. Browning collected, he said the 30% should be given to DMT. And very quickly, one last point is that, I'm sorry, I'll go, my time's up.
Yeah, go ahead, counsel. I gave extra time to your opponent.
All right. Thank you. So the fees that, excuse me, I lost my train of thought.
You're also allowed to rest on your brief. That's fine. Thank you, counsel.
If I could just make one closing point here, I think it's very important that everyone here essentially agrees that the lower court got the standard wrong. The FAA was applicable and it was not applied. Now, the Court of Appeals, when confronted with this situation, in that instance, that was the end of the proverbial conversation.
Had the arbitrator applied the FAA, you're saying that the arbitrator would not have found that there was a breach of the agreement by both parties?
I don't know, but I am saying the fact that the arbitrator did not apply the FAA in itself is reversible error. The Court of Appeals, when confronted with a similar instance, did not go further than that. That's the analysis. The FAA was applicable, you didn't do that. The case is remanded for further consideration. And everyone here, I think, agrees that the court erred by not applying that federal standard of law. And again, manifest disregard of the law is black letter law. There's something that's clear, that's undisputed, and it was not applied to this case. I think that itself is evidence on the face of the arbitrator decision, as sparse as it is. Unjust enrichment, just as an example, again, is not something that applies when you have a express written contract, right? We have a clear example of a manifest disregard of the law, on top of other instances that we have briefed, including the fact that there was no consideration whatsoever of the bad faith claim that DNT raised. All of this taken together, again, with the fact that there is no reasoning for the decision.
Even though counsel says that both parties agreed that they didn't want anything extensive.
Nothing extensive, fine, but there is no, that's different from there is no rationale whatsoever. It's literally, I think, a handful of sentences, just a couple of sentences, if anything, right? And
Is more required? Normally, is more required rather than a brief explanation as to why the arbitrator finds the way the arbitrator finds?
Right, so I think it is clear that an arbitrator is not required to explain the decision, but the fact that an arbitrator failed to explain does militate in favor of a finding of manifest disregard.
Thank you both. Justice Michael is recused on the next matter, People versus Kasim Williams. Please.
May it please the court, Rosemary Herbert, Office of the Appellate Defender, on behalf of Kasim Williams. In this case, the psychiatric examiner spoke to Mr. Williams jointly for less than 10 minutes and never asked him about his understanding of the charges against him or his ability to assist in his defense. Under these circumstances—
Is there anything in the law that requires that an examination, a 730 exam, be of a certain length?
Absolutely not, Your Honor. In fact, the only language of the statute that it be consistent with professional practice. The examiners at the hearing in this case, both of them testified essentially the same, that their examinations typically lasted between 30 and 45 minutes. So by their own testimony, this was significantly shorter than—
And is there a reason why this examination was shorter than the traditional examination?
Yes, because Mr. Williams, according to the examiners, refused to speak to them, refused to engage with them. They noted
What
that
were
he
they
was
supposed to
polite.
do once he refused to engage with them?
Well, again, it is not at all uncommon for people suffering from mental illness to be mistrustful of those questioning them. And in this case, the examiners did not try very hard. They did not ask additional questions. They did not probe. They did not ask for a second interview to be scheduled. They did not ask for the court to intervene in any fashion. They did not come back to the court and say, sorry, we can't do this examination that we have been ordered to do because Mr. Williams will not speak to us. They simply took the very limited information they had. They ordered some prison medical records, the most recent of which was, I believe, more than 6 months old, and they made a determination that he was fit. That is not the full and impartial determination that Article 730 contemplates and that he was entitled to ensure that his trial, that he was not an incapacitated person, and that his trial conformed with due process.
Is there anything in the record after this 730 exam was purported 730 exam was done? Is there anything in the record at the trial level that would indicate that Mr. Williams was somehow unfit to proceed?
Yes, Your Honor. The reason why his attorney repeatedly begged the court to order a 730 examination was, and I'm using the attorney's words, that his obsession with certain legal issues had sort of morphed into a delusion.
That was the jurisdiction of the court. That's what he was obsessed with.
It was a variety of factors, but that was the one that the recurring theme was the jurisdiction of the court and concerns about the legitimacy of the indictment in that case. And throughout this case, this was not a momentary thing. Throughout this case, as a result of his repeated arguments about this. The grant of his ability to go pro se was revoked by the court. His request for a bench trial was curtailed, and again, that's another issue in our brief, and he was ultimately removed from the courtroom. So the attorney's concerns seem to be very much borne out by what transpired later on. And in fact, the few phrases that the examiners reported in their report that Mr. Williams conveyed to them, again, are exactly the obsession, delusion that his attorney was concerned about. And so the fact that they didn't engage him further, that they didn't probe, that they didn't ask for a second interview, shows that this did not comply with what is contemplated under Article 730.
Is the fact that he was considered to be disruptive through a pretty much a lot of the proceedings in the trial level, does that have any bearing on his fitness to proceed?
Again, I mean, certainly to a certain extent it does. It certainly is, it was, I wouldn't necessarily say disruptiveness, but this sort of fixation on these issues was, I said, the reason that prompted this examination to be undertaken in the first instance. And at the hearing, the examiner said that they had reviewed some of the transcripts leading up to this, so they were certainly aware that he had these concerns, and the fact that they did not take any type of measures beyond the few initial questions to try to draw him out, to engage him on those issues, I think speaks to the inadequacy of the determination. And under those circumstances, the conviction must be reversed. Thank you.
Thank you. You have time in rebuttal as well.
Good afternoon, Your Honors. May it please the Court. Jonathan Sklar for the Office of Darcel D. Clark. Your Honors, the two medical examiners observed defendant for 10 minutes. They observed his grooming, his hygiene, whether he was responding to internal stimuli. They observed him. They heard him discuss his legal theories, and they concluded.
Well, no, but he didn't discuss his legal theories at the exam, did he?
He did, Your Honor, briefly. He said this...
He just said, I'm not talking to you until the Article 78 decision comes down, basically.
He said the case is being argued over jurisdiction, and it's in the higher courts, and I won't speak until those matters are resolved.
But then they went on to consider the medical records from 2015, in which he has a very, very superficial discussion about the legal case, and said, as a result of that, and your opponent makes a good point on this, that showed that he understood his legal situation. And it just seems to me that was an extremely I'm not a psychologist, obviously, but it seemed like a very superficial analysis to me.
Sure, they didn't exclusively rely on that. They used those medical records to confirm that he did not have any cognitive inabilities or major mental defects. He wasn't suffering from hallucinations, any schizophrenia, incapacity condition, et cetera, et cetera. And they determined, based on their short meeting with him, which is all he would allow, plus his medical records, that he wasn't suffering from any incapacitated condition. Your Honors, the record bears that out. The court allowed him to go pro se for a while until they realized he wouldn't focus on the legal claims against him. And he filed pro se Article 78 petitions. He argued his case pro se in Manhattan. It's absolutely absurd to say that he didn't understand the legal charges, the claims against him, the offenses he was accused of. His attorney never said, "Well, Your Honor, he doesn't understand the case." He just wasn't cooperating.
Was there a hearing held on whether or not he was fit to proceed? Did the court hold a hearing?
Yes.
And at that hearing, did the two doctors, psychologists, psychiatrists testify?
Yes.
Extensively about their conclusions?
Correct, Your Honors. Okay, so moving on, just briefly regarding the denial of the bench trial request. So the statute's very clear. If the court is not convinced that defendant understands the implications of waiving his jury trial, the court cannot grant that request. Your Honors, defendant clearly said, "I do not understand," when the court allocated him on it. And then the court went on to state its reason on the record. It said, if he had cooperated with my inquiry, then I would have granted the bench trial request, but he didn't, so I couldn't. And then finally, the record speaks for itself regarding his disruptiveness. The trial could absolutely not continue with him in the courtroom. The court gave him 10 to 15 warnings. He was yelling for multiple rants, multiple minutes, and in an angry voice. He interrupted the judge on multiple occasions. He insulted the jury's competence. The record speaks for itself on that. And if you have no further questions, we rely on the brief.
On the, I have one question on the issue of the waiver of the jury trial. He requested that after 10 jurors had already been selected.
Correct.
What's the significance of that?
Sure. So we submit that that was untimely. The statute says that a trial that you can request to waive your bench jury trial before trial begins. Trial begins at the commencement of jury with jury selection. So there's a question of whether it's the commencement of jury selection or the end of jury selection. There's a Court of Appeals case, People v. Crespo, that says in the self-representation context, the trial begins at the selection of the first juror, and there's no reason to believe that it would be different in this context because it's for judicial economy's sake. It doesn't make sense to select a jury, most of the jury, and then entertain requests for a bench trial. Your Honors, we ask that you affirm. Thanks.
Thank you very much.
Very briefly, on the bench trial issue, there is decisions from this court finding that a request is timely when made in precisely this situation where some jurors have been selected. Those cases are cited in our brief. They're the Williams case and the Rodriguez case. So this was absolutely timely. The judge recognized that it was timely. The judge simply grew frustrated because of the behavior that counsel had identified in seeking the 730 and terminated the inquiry. He did not make the findings that are required by the statute before a request to proceed with a bench trial may be denied, and the statute is quite specific on that. He simply speculated that, well, I'm not sure he really wanted that. I would have entertained that if he had come back in here. That is not the finding that is required. The judge has very limited discretion in his ability to deny a bench trial, and the requirements of the statute were not satisfied here. If I might very briefly return to the competency question, my adversary talks about another case where Mr. Williams went pro se. The problem is there was absolutely nothing in this record, nothing in the examination conducted here dealing with Mr. Williams' ability to assist in his defense. I think that is the critical issue here. It is a critical component of competency to stand trial, and there's absolutely nothing here that sheds any light on that. The medical record that was referred to—
Is there a distinction between ability and willingness to participate?
That was a distinction that the examiners made, but again, until the examiners had some insight into what was going on with him, I don't know how they could possibly have opined on whether this was capacity or whether this was willingness. And with regard to the medical record, one of the doctors in her testimony said, when asked about, well, did you talk to him about his case and his ability to assist in the defense? And she said, he's fit because it says so in the medical record. And then she quoted from what is in the medical record. And the only thing that is in that medical record is the patient reports he was recently brought back to Rikers in April on a different charge stemming from 2011. His court date is tomorrow. That doesn't indicate fitness at the time it was entered in 2015, and it certainly doesn't indicate fitness and an ability to assist with his defense.
Could that doctor have been talking about the absence of any psych history, because there was no psych history on this defendant?
That's absolutely clear. But again, not everyone. We've certainly encountered many, many situations where people have an undiagnosed psychiatric history. Psychiatric conditions develop over time. So that is certainly a factor that the examiners were entitled to consider, but it cannot be dispositive with the very limited information that they had at the time. Thank you, Your Honors.
Thank you both. Wait for Justice Michael to return. Next up is 174th TIC Owner versus Nyblack. You may proceed, counsel.
May it please the court, I am Stephen Wegg, representing the appellants in this case. It's respectfully submitted to the court that the lower court erred when it determined that this case had to be brought as an Article 7 under the RPTL as opposed to Article
I have a
7.
question for you. Is there anywhere in the record where we can find that the DOF did an assessment?
That the DOF did an
Assessment of the property.
went down to the property and looked?
Yeah.
There's nowhere in the record, Your Honor.
I'm looking for that, so.
It's not there, Your Honor.
It's not there.
It's not there. There's nothing in the record that shows that they went down there. There's an extensive, we put in the assessor's handbook, there's an extensive review process that should have happened, including sketching the property, determining whether or not the installation of windows and heating system and installation and all of that caused an increase or decrease in either the land or in the physical of the property. It's not there.
But is that a clerical error, though?
Well, the clerical error is proven because the equalization did increase afterwards. So there was something that triggered that equalization to increase. And according to the CER, which gives the specific example of new construction performed, the equalization increases, but there's no physical, that would indicate that there was a clerical error and that the...
It sounds like an error, but is it a clerical error? I mean, again, your opponent points out that clerical errors are like math, incorrect math problems or a typo or something like that is a clerical error, not this major omission that, well, we're not saying happened, but if it did happen, it would be a big omission.
Understood, Your Honor. The example that Commissioner Jihop put specifically into the CER goes well beyond, and there's, I believe, 16 different categories and examples. It goes well beyond just a mathematical error. It says straight out, the assessment roll does not reflect the physical increase subsequent to the completion of the work. That's more than just a math error or somebody didn't carry the one when they were doing the mathematics. That's an equalization that recognized something happened at the property, should have been put in as a physical, but it went in instead as a equalization. Now, just popping back a little bit to where we were starting with this, we're not talking in this case about an exemption or a miscalculation or evaluation. This case is very targeted, and I appreciate that the court has already targeted on that issue. It's very targeted on what specifically happened, and the interpretation that DOF is asking for would essentially render the CER to be meaningless, because the 16 examples in the CER would no longer be able to be determined by the Department of Finance. According to DOF, they would have to go to the Tax Commission when the CER was intended originally to be separate and apart from an appeal to the Tax Commission, which is why it can't also be brought as an Article 7, because an Article 7 is only for cases that are brought before the Tax Commission. The Tax Commission has to be served with an Article 7. This is extremely different because it's an administrative determination.
What about the settlement agreement that you have?
There are 2 points on the settlement. The first is that the settlement was never raised in the administrative proceedings, so it shouldn't have been reviewed by the lower court in the first place. But secondly, the settlement only talks about valuation. We're not talking about valuation. It says that the petitioners, the appellants, will not challenge the assessed values or the class of the property, neither of which is what was raised before DOF in the administrative proceeding under the CER. It was simply, there's a clerical error, the physical should have been there, it's not there. The appellants didn't tell the DOF what that physical should have been, what that amount should have been. It's a little bit odd that the DOF has raised, well, you never told us what that physical amount should have been. That's exactly the point. This isn't about valuation. This is about a clerical error. DOF and the assessor is supposed to figure out what that value is. And DOF and the assessor, seemingly, they say that they did, but they don't prove that they did. There's nothing in the record showing that they did. But it's DOF that is supposed to have come forward and said, well, we did go down there, and this is what we found. It never happened, apparently, according to the record, at least, and that's why the lower court should be reversed, and the administrative determination should be set aside and remanded back down.
Thank you, counsel.
Thank you.
May it please the court, John DeBaptist on behalf of the Corporation Council of the City of New York, representing respondents, Commissioner of Finance, and the City of New York. Your Honors, we are here today to ask the court to affirm the lower court's decision which dismissed Appellant's Article 78 on 2 grounds. Regarding the first ground, the court correctly held that in entering into a binding settlement agreement with the Tax Commission on July 23rd, 2019, appellants agreed to the finality of tax assessments for tax year 2019, 2020, and prior tax years.
But counsel says that that was not part of the administrative record below.
Your Honor, the settlement agreement, as this court has held in matter of oversight management, tax commission settlement agreements are binding. In that case, just as in this case, there was a clerical error that was brought through in Article 78, such as this case, on tax years that were settled in the tax commission agreement. And this court found that pursuant to the plain terms of the agreement, petitioner in that matter was foreclosed from challenging finances determinations through an Article 78 of the CPLR. In fact, the terms of the agreement, Your Honor, are clear and unambiguous. The terms are found in the record, pages 512 to 515, and they state in an abbreviated form, I'm going to just abbreviate, appellants accept the proposed assessment. No proceeding could be commenced as to current and prior assessments. All open proceedings to review current and prior assessments would be discontinued, and assessments for prior years would be confirmed without adjustment. And most importantly, there's a definition for what a proceeding is. Among other things, it states that it's a judicial action which seeks a change in assessment or any substantially similar or related relief, including declaratory, injunctive relief, and a proceeding based entirely of issues of law.
So even if there was no assessment done in this case, let's say, that settlement agreement would preclude this proceeding?
Your Honor, I'd just like to clarify that every parcel of property is assessed as of January 5th of the taxable status date. An assessment just consists of 2 different components, land and building value. I think what you're referring to is whether, an assessor went out to the property, which an assessor, we don't know. That's not in the record. But the issue is that the settlement agreement, petitioners, what they did in entering into the Tax Commission settlement agreement, basically they agreed to be bound by that agreement and not challenge any assessments from 2019, 2020 tax year going back. And here we're dealing with claims 30 years ago. I mean, from 1989. That's one of the reasons why, even despite the settlement agreement, this case, shouldn't even be before this court, because, the clerical error rule that petitioner cites consistently, in fact, has a 6-year look-back period, which basically would bar any type of, would bar finance, even if finance agreed that a clerical error in description had been committed, which obviously we do not. Appellants still would not be entitled to relief because that 6-year look-back period doesn't extend, 30 years into the past. Regarding the second ground of dismissal that the lower court, cited, they correctly held that challenges to a physical increase are challenges to valuation exclusive to an Article 7 proceeding. This court has recently held in matter of Bajaktari that was decided earlier this year that challenges to a lack of a physical increase are not a clerical error in description, but rather they're issues of valuation. And this court has done the same in matter of 9 Orchard and Craybell versus Department of Finance. Thank you.
Thank you, counsel.
If I could just correct one a point about the case oversight management, which DOF cited. Oversight management was a case that addressed a change of class. Change of class is explicit in all of the Article 7 settlements. So when this court determined in oversight management that it was barred by the settlement agreement, it's because it was specific that a change of class is barred by the settlement agreement. It's also just to note that counsel also, and I'm quoting, tax commission agreements are binding. This is a case that's not against the tax commission. This is a case against DOF, which is what the CER permits. CER is separate and apart from the tax commission. Also, to get to Bajaktari, in those cases, the physical, or the cases speak about the valuation of the physical. That's what the property owners were disputing. We're not disputing the valuation of a physical. We can't, because there was no physical. And that's why this fits squarely into the CER when other cases did not. I also want to talk about the 6-year look back, because that's a little bit tricky. The 6-year look back allows DOF to look back. Say, for example, we filed something today. DOF could look back 6 years from today, and if there should have been a physical even 20 years ago, but it carried through, that physical would still be within the 6-year look back. Now, this was first raised before DOF in 2005. This has been going on for 17 years in administrative proceedings until there was finally a determination by DOF. That means that it goes back to, let's say 1999 would be a 6-year look back from when the original proceedings were started. So this is long running, correct, but it's not as absurd as counsel would try to make it seem. It's perfectly normal that this type of thing, it's not normal that we would wait 17 years for determination, but it's normal that there would be a 6-year look back from the original filing.
How is this settlement not a bar? Tell me again. I know you mentioned it.
The settlement resolves issues of valuation and class, which is what, whether it's a class, let's say 2, or let's make it easy, a commercial building or residential building would be a class, let's say. So that's what the settlement agreement resolves. It doesn't resolve something that's in the CER specifically, which is whether or not a physical was applied or not. That's not included and spelled out in the settlement agreement. So that's why it wouldn't apply. If Your Honors have no further questions, we'll rely on
Thank you,
that.
counsel. Thank you both.
Thank you, Your Honors.
A&D Family Homes v. Rivka Herz. Please.
Forgive me, I'm new at this and I'm unclear. How many minutes do I have?
You have 4 minutes at the outset and then 2 minutes to respond to your opponent's argument.
Thank you. May it please the court, my name is Rivka Herz. I stand before you today as a pro se appellant challenging the lower court's judgment. Firstly, lawful occupancy. The 2011 matrimonial court order explicitly granted me lawful occupancy of the unit in question. For over a decade, this order went uncontested by both the respondent and Stephen Alevy, who controlled the respondent entity. And I refer to
Your opponent says that that was superseded by the final judgment of divorce. What do you say to that?
So, as I'm going to explain, the final judgment of divorce came later in 2021, and this case was prematurely brought because there was an order in the matrimonial case from 2011 that granted me tenancy there. As I'll explain further, Stephen Alevy is really one and the same as A&D Family Homes. He was actually the signer on purchasing the apartment, so he was fully aware of the fact that I was granted that tenancy and that I was permitted to be there through the course of divorce. So, in essence, it was brought prematurely, and if they wanted to deal with the financial end of things, number one, that cancels out their moot argument, and number two, that also should have been dealt with in a filing at the proper time, which is post-divorce. It shouldn't have been brought pre-divorce. Can I continue, or is there?
Sure.
Okay. I'm quoting Murdoch versus Ward, which I don't have to expand on right now unless you want me to, but that's with regard to that point. The second point, the doctrine of collateral estoppel, which further supports my right to lawful occupancy. The respondent argues that collateral estoppel cannot apply because the 2011 order was labeled temporary. However, despite the order being termed interim, it was treated as binding for over a decade. This long-term acceptance grants the order a significant degree of finality. Third, the respondent's attempt to eject me was initiated, and this is what I mentioned, while the 2011 court order was still in effect prior to the divorce. When they later attempted to add rental claims to the same filing, and then they finagled the amounts of the rental filing based on the 2011 order being in effect, which would thereby not give them the rental at that point versus thereafter. Again, it was done with a premature filing, and they did it without following proper procedure. These rental claims should have been pursued through a new filing reflecting the changed legal circumstances, and I ask this court not to allow the respondent to retroactively validate a defective filing by tagging on claims that may or may not be legitimate. Next, the concept of notice doctrine and the involvement of Stephen Alevy. The principle of notice doctrine, which the respondent has disregarded, holds that a party acquiring property with knowledge of existing obligations is legally bound by those obligations. In this case, Stephen Alevy, who actually represented A&D Family Homes during the acquisition of the apartment, was fully aware of the support obligations established by the 2011 matrimonial court order. These obligations protected my tenancy rights, and A&D Family Homes, via Stephen Alevy, was aware of them when acquiring the property. To that end, I quote Julian J. Studley, Inc. versus New York News, Inc. Next, the lack of separation between A&D Family Homes and Stephen Alevy. With regard to that, there was a corporate structure, A&D Family Homes, but there was a lack of separation between them because A&D Family Homes had failed to provide any rental agreements or receipts from Stephen Alevy that would have proved that they operated as two separate legal entities, the reason being there were none, which for all practical purposes shows that they were actually one and the same entity, which deals with the concept of corporate veil thereafter and piercing it. I'm red. Can I finish up? Or
You'll have time on rebuttal.
okay, thank you.
Thank you.
Good afternoon, and may it please the court. My name is Gregory Bogopoulos, and I represent the respondent. Regarding the appellant's argument about the ejectment action, this court has already dismissed that appeal in an October 2023 order, and appellant essentially mooted any argument about that by voluntarily surrendering the apartment by stipulation in April of 2023. So I'm going to concentrate my discussion on the money judgment, which is also being appealed by the appellant. As the court knows, a summary judgment motion review consists of whether or not there is a genuine issue of material fact in the record. There was no genuine issue on material fact.
What about the 4,000, the quantification of rent at 4,000 a month? Is that definitive enough?
I agree. I think so, Your Honor, because not only did the appellant think that was the case by stipulation, not only did her ex-husband, our client, the respondent, also thought that was $4,000. So the issue then becomes whether or not the respondent can argue or set forth sufficient evidence for a hearing for a set-off of that amount per month. She did not. She submitted some photographs. They weren't really authenticated, but there was no allegation of notice of the conditions to the respondent. There was no allegation of access for the respondent to repair. In fact, in the reply papers, affidavits were submitted, not only that the respondent was not aware of these conditions.
The quantification comes in what could be called a stray comment, or it was a stipulation, I guess, so you can't say it's stray, but was that in the civil court?
The stipulation she entered into regarding the market rent?
Yeah.
It was in the matrimonial action.
In the matrimonial action. Okay, do we know enough about the context that stipulation was made to say that it's definitive?
I think so, Your Honor, because what happened after that is the referee incorporated that stipulation into the report.
But counsel, if you look at the record, when we talk about it, it just says simply from one lawyer, you want a stipulation of what reasonable costs would be. You say $4,000 to $3,500. Is that what you're looking at? Let's stipulate. And it just says, I'll stipulate. There's no other indication that there were any comps or anything that was reviewed to say that that was the actual value at that time.
What the problem is that the appellant never actually, in her affidavit in opposition to the motion, raised those arguments. She then only raised the issue about, oh, my apartment has conditions that need repair, so therefore the market value is $4,000 a month. There was no, and again, I will reiterate, that agreement about the $4,000 was incorporated into the referee's report, which was confirmed by Justice Cooper into his judgment of divorce. And of course, that judgment was affirmed, not to the child support part, but as to the maintenance. And that part went to the maintenance that the appellant was entitled to or not entitled to. So without any real dispute that $4,000 a market rent is the rent, that is the rent in the record. And we request the court affirm the judgment below. Thank you.
Thank you, counsel. You have 2 more minutes.
Okay. Can I continue where I left off before, or must I only address that which he said?
You're free to say, talk about anything that you think is relevant to the case that you've raised in your papers.
Thank you. So just very, very briefly to finish up what I was saying before, Stephen Alvey and A&D Family Homes were really one and the same, which means that this whole entire action, regardless of anything the other side is bringing up, is moot. Moot in the sense that it was brought prematurely, not moot in the manner in which they're using. When they're saying that the case is moot, and I'm standing here with absolutely no reason to stand here, then in that case, there shouldn't be reason to be asking for financial claims. It's either one or the other. I'm not talking about ejectment, which is what the court has already stated I cannot appeal. I'm talking about the case as a whole. The case as a whole should not have been brought at that premature time when there is actually another case in the Supreme Court with an order that took care of those very same issues. So that's my distinction. In terms
What
of
about the value of the apartment?
So I was going to get there. Thank you for asking. Just to address that, when your honors were asking about the $4,000, the context of that is that we had a very long matrimonial trial. We were standing in front of a referee, and we were dealing with the financial aspects in front of the referee. It was a non-expert opinion. We were put on the spot with regard.
You did agree to it by stipulating.
So
right?
the attorney that represented me ultimately agreed to it and stipulated to it because we had no choice.
On your behalf, though, right?
Yes. Well, he represented me, yes. But I'm sorry, I didn't mean to be coy with that. He stipulated to it because we were in the midst of a hearing. We were pressured to come up with some sort of number, and we did not have an expert value on that. We were given a very limited amount of time. We were put on the spot to do it.
Did you ever raise that issue before, that you weren't given sufficient opportunity to put a real value on the apartment?
In front of Judge Gotts on this case, I actually brought up when I was doing, I forgot which aspect of it, when I was representing myself. I think it was a renew and re-argue. I brought up a real estate agent who was very familiar with the property, her assessment of market value, and from the time that $4,000 was stipulated to until the time of this case having come up, market conditions shifted, market conditions changed. That's just the way of the real estate world. Values go up, values go down, property changes, and so in addition to showing pictures, which whether or not they were admissible and I did it properly, I showed pictures in our court filings of the state of affairs in that apartment. The real estate broker, real estate agent did an assessment of actual comps. So we're not even talking specifically the damages in the apartment or what the condition of the apartment is. We're talking about actual comps on the market at that very same time that this was brought.
Thank you very much. We also have your brief.
Thank you very
both.
much. Thank you for your time and consideration.
DeVito versus Ye. Please.
May it please the court, Kyle Monahan of Milman Labuda on behalf of plaintiff appellant. The court misapplied the pre-answer motion to dismiss standard to provide plaintiff with every favorable inference. The court also misapplied the governing standards under the state and city human rights law, ignored precedent that demonstrated that plaintiff had plausible claims as alleged. It also took into account inadmissible attorney statements, and instead, rather than the harsh penalty of dismissal with prejudice and sanctions, the court should have granted, if it had concerns over plaintiff's pleading, leave to amend. And then lastly, regarding sanctions, as demonstrated in her briefs and herein, plaintiff had a reasonable argument to claim that the New York State...
You knew that the defendant was going to ask for sanctions, though, right? That was in their brief below, and you responded. You had a chance to be heard on that question.
Yes, Your Honor.
Okay.
But again, plaintiff's position would be that there should have been a reasonable, she had a reasonable argument to believe that the New York State and New York City, especially under the New York City with its liberal standard, should have at least she had a reasonable argument to believe that it would govern these types of cases. So with regards to the misapplication of the standard on a motion to dismiss, The court found that plaintiff's claims that she was denied a promotion were purely speculative. However, in her complaint, specifically paragraphs 19 and 20, she complains that after Ye began employment with Dolce & Gabbana, the leadership position that plaintiff was promised was no longer hers.
But counsel, she never applied for it.
She was told that she was going to be given it by her managerial staff, and that
Was she told she
alleged.
wasn't getting it?
She was, and in fact, if we would have been provided the opportunity to continue with discovery, we have a tape recording that confirms that defendant blocked the promotion for her. So she has a promotion guaranteed to her when it becomes available in June. This is in January of 23, and all of a sudden,
So the promotion had not become available to her at the time that she's saying she was blocked from getting the promotion?
but it was guaranteed to her, and then all of a sudden, it's no longer guaranteed to her.
But the promotion itself, right, had not become available at the time she was saying she was
Not
blocked
yet,
from it.
but it would be plaintiff's position that effectively by being told she's not being considered or she's not the only one to be considered, it's not no longer guaranteed to her.
But she's not being considered for something that's not even available yet.
But she was told before that it was hers when it becomes available. I mean, this is a position outside of the state in a separate state that she's going to have to take time to relocate. So she was told this was her promotion to obtain, and now it's no longer hers.
When she was told that, was she told that we are not going to interview anybody else?
That is what we alleged in the complaint as well, that it was hers. There was no one else to receive this promotion, and then all of a sudden, defendant now who she had filed an arbitration against for prior what she believed discrimination, he comes to her employment. She was at Dolce & Gabbana for 6 months prior to defendant becoming her supervisor there. She's a stellar employee there. All of a sudden, this promotion that's hers is no longer hers. And in fact, in team meetings, he's not making eye contact. He's ignoring her. And so she feels ostracized at her new location.
What is the proof that she's not getting this promotion because of Mr. Ye?
Well, I think that's kind of putting the cart before the horses. We're still at a pre-answer motion to dismiss. The pleadings itself have to be given liberal construction and taken alleged as truth here. That's what we allege was fault by the court below. Was her complaint itself was not given that was not afforded the truth as it was alleged.
What allegations were made that this was the case, that Mr. Ye somehow prevented her from getting this?
Well, like I stated before in paragraph 19, 20, and 25 through 26, we specifically allege that she was promised this promotion and it was no longer hers. And it is clear that defendant was the reason for the withdrawal of the leadership position, and that the retaliation was based on this ostracization of plaintiff at meetings, and that defendant interfered with the promotion. I mean, the timing.
Counsel, to state an allegation for retaliation, you have to show that the plaintiff has suffered some sort of adverse employment action. The promotion's not even available yet to anyone. So how can we say she's stated some sort of adverse employment action?
Well, that was to my second point, that the New York City human rights law is that the adverse action has to only reasonably likely to deter a person from engaging in the protected activity. So here you have a plaintiff who files an arbitration. She's a stellar employee at her new job. One of the individuals at the arbitration that she's alleging discrimination against comes and works at her subsequent employer. All of a sudden, this promotion that was hers is no longer hers. I mean, that would be, I think it would reasonably deter any individual from filing an arbitration against someone else with the risk of them following them to a new employer and then blocking promotions there.
Thank you. You have time in rebuttal.
Thank you.
May it please the court, Melissa Overbeck, prosecutor Rose for the defendant Appellate, Jimmy Ye. This is a complaint that is plainly subject to dismissal because its allegations are insufficient to state a claim under any of the causes of action alleged. Contrary to what Mr. Monahan said, the complaint only alleges 2 actual forms of conduct in the 2-week overlap that is at issue here. First, that plaintiff was ignored by Mr. Ye, both before and after he joined Dolce & Gabbana. And second, that plaintiff was told that she would no longer be the sole candidate considered for a future promotion that would become available in 6 months. Both allegations, taken as true, as they must at this stage, are insufficient as a matter of law to state a claim for retaliation, for tortious interference, or for intentional infliction of emotional distress. As to the ignoring, what the complaint actually alleges is that Mr. Ye visited the store plaintiff worked in, he made eye contact with her, and then he ignored her. That occurred before he was an employee, and it occurred after he was an employee. But
What
that's
about
it.
the meetings with the staff?
There were no meetings alleged in the complaint. The complaint only uses the meeting in one place in the entire complaint. And it says, in reference to the time when Mr. Ye was not yet an employee, that Mr. Ye visited Dolce & Gabbana on January 11. He made direct eye contact and ignored her as if she didn't exist. During this meeting between plaintiff and Ye, he ignored her. So he's not even an employee, so he clearly cannot be having company meetings at that point. The word meeting doesn't appear anywhere else in the entire complaint.
So ignoring someone when you see them is not extreme and outrageous conduct?
We would say no. And in fact, the minimum threshold that you must pass for both the city and state retaliation claims is petty slights and trivial inconveniences. And we would say, as the law says, that ignoring does not rise above the level of a petty slight. If it doesn't, what possibly could?
We haven't talked yet about the tortious interference with prospective economic advantage claim yet.
Okay.
You say in your brief that the conduct was aimed at the plaintiff, not at third parties, and therefore it couldn't qualify under that cause of action. But wouldn't it be possible to direct some conduct at the plaintiff to be demonstrative toward third parties, to show your contempt for the plaintiff? And couldn't that give rise to some interference with the plaintiff's potential economic advantage with other parties?
It's possible that it could have that effect, but that's not how the case law understands tortious interference. The party is supposed to be a third party to the relationship. So first of all, Mr. Ye, as a D&G employee, can't be a third party to D&G's decision. Second, what he is alleged to have done is encourage them to consider other people for this promotion, which is squarely within his role as a supervisor. And again, the only thing he's accused of doing is ignoring her on this handful of occasions in a 2-week period.
What is the significance of her resigning before she applies?
It's very significant because it results in the entire promotion claim being completely speculative. Because she never actually waits for the promotion to become available, we don't know if it actually would have become available. We don't know if anyone else would have actually applied. We don't know if D&G would have actually interviewed people. All they said is that they were going to do that in 6 months when this position opened. So we can't possibly know whether she would have been discriminated against with respect to this promotion because she resigned before we ever get there.
Thank you, counsel.
Contrary to what was just stated, also in paragraph 17, the plaintiff alleges that after Ye began employment, defendant began employment, he continued to visit the location that plaintiff worked at and would ignore and ostracize plaintiff by continuing to ignore her. So again, it's you, and you have 2 buckets now of this ignoring, right? It's the first date before he started, and then the second time of when he's now working, he's continuing to ignore her. So I guess with the first instance, with when he's not an employee, then that would lead to a tortious interference claim, right? Because these are actions that he's taking prior to becoming an employee. But with regards to these allegations, we're forgetting that these, or I guess we believe that the lower court ignored that these claims have to be taken as a totality of the circumstances. It's not a piecemeal, okay, she was ignored. You have to also consider the fact that she alleged that she was guaranteed a promotion and it was no longer there. So when you couple that with the ostracization, we believe that she sufficiently took alleged a complaint sufficient to withstand a motion to dismiss, and in any event, certainly sufficient to not warrant sanctions in this case. Thank you, Your Honors.
Thank you very much. Thank you both. People versus Channing Parker. Please.
Good afternoon. May it please the court, the Legal Aid Society by Mimi Lee, appearing for the appellant Channing Parker. Mr. Parker's sentence should be vacated and remanded because the trial court erred in sentencing him in a felony case with a deficient pre-sentence report. In this case, Mr. Parker was in custody at Rikers, and the Department of Corrections did not produce him for his interview with probation for the purpose of...
If the waiver was valid, though, you do concede, if the appeal waiver was valid, you do concede that it would encompass his claim that he should have been interviewed for the PSR. You do concede that, do you not?
No, Your Honor. It's actually, the purported waiver is not valid because it conflates the trial issues with the appeal waiver. But
if it is valid, though?
Even if it is valid, it does not preclude this claim because the appeal waiver was executed prior to sentencing.
Okay.
And the report does not have the necessary information required by Article 390. And the absence of this information meant that the trial court could not properly execute its sentencing function in determining the appropriate sentence for Mr. Parker. This is not only mandated by statute, but it's emphasized by the Court of Appeals. In People v. Selikoff.
At the time of sentencing, did Mr. Parker object to being sentenced without the pre-sentence report?
So, Your Honor, defense counsel did consent to proceeding with sentencing at the time. However, it's our argument that this is not something that counsel could have waived because it's statutorily mandated. And the Court of Appeals in Selikoff has stated that a judge may not ignore those provisions of law designed to ensure that an appropriate sentence is imposed. And
well, it's not that a pre-sentence report wasn't prepared at all. It's just that Mr. Parker was not interviewed, but a report was present, right?
A cursory report was present. It was very bare bones and skeletal. It did not have any of the required information by statute. And the Court of Appeals has stated that we need more than just a cursory form report filed. In Ferrer, the Court of Appeals stated that the promised sentence at plea is not fixed at the time of plea. It doesn't automatically become the court's sentence because there's information that's required that was not yet available at the time because it had to be prepared in a pre-sentence report.
Is it required that a defendant be interviewed for that report to be generated?
There is not a specific requirement that the defendant is interviewed. However, most of this information is gleaned from the defendant's statements, and there is a requirement for the information to be in the report.
So aside from pedigree information, name, date of birth, address, criminal history, a recitation of the facts of the present matter, possibly a victim impact statement, what was missing from this report that was so essential? A statement from Mr. Parker?
Yes, regarding the regarding the circumstances of the offense, any type of family, social history, individual circumstances, mental health,
And if there were any mental health issues, I'm sure that would have been included in whatever information that the Rikers had for him, correct? Whether he was on any medication, that sort of thing, right?
None of that was ever entered into the record at sentencing. And, you know, although that information could have been out there, it wasn't in the report. And so because of that, as this court is aware, the pre-sentencing report is extremely important in the criminal justice system. It follows the defendant long after he's convicted, is heavily relied upon in direct appeals. Probation uses it. For Mr. Parker is of particular consequence given the nature of the case. It'll be used by the Board of Examiners in his future SORA hearing. And should this court decide otherwise regarding the waiver and the appeal waiver, we would still ask this court to reach this issue in the interest of justice. Moving on to the excessive sentence claim, Mr. Parker spent years suppressing a mental health disorder that he did not understand nor even knew he had, eventually succumbing to his impulses and regrettably committed acts of a sexual nature against 2 minors. The offense here is very serious, and Mr. Parker recognizes the harm that he caused. However, we would ask this court to note that his sentence of 20 years imprisonment is unduly harsh. I'll reserve the rest for.
Thank you very much.
May it please the court, David Gagne for the people. Your Honors, there was a valid waiver of appeal here that precludes review of both of his claims, including the claim regarding the PSR, and I'll point this court to People v. Smith and People v. Davis. In any event, defendants claim that the PSR was so deficient as if to be a nullity is both unpreserved and meritless. This was a negotiated plea where the defendant received the same sentence that he was promised. If he had wanted to be interviewed by probation, he could have requested an adjournment at sentencing. He didn't do that. The court asked defense counsel whether he had reviewed the PSR. Counsel said yes. Was there any reason not to proceed with sentencing? Counsel said no. So clearly counsel considered this PSR sufficient, and there is plenty of information in the PSR that's relevant to sentencing. On the ES claim, the sentence reflects the grave nature of the defendant's crimes. This is a case where we had victim impact statements from both of the 9-year-old victims. And if there's any question about whether the sentence should be reduced, I would just respectfully urge you to go back and look at those victim impact statements.
You quote from them in your brief, effectively. But he faced a max of 25 years, right, on what he pled to. If he'd gone to trial on the top count, he would have gotten, or he faced 32 years, is that correct?
I believe that's correct, Your Honor, yes.
But he had no priors. You concede that, obviously.
He had no priors, that's right. He was, at the time of sentencing, he had pled guilty in the Bronx to first-degree sexual abuse. He was sentenced the day after sentencing in this case. Unless there are any further questions, we ask that you affirm. Thank you.
Any further questions? Thank you.
Your Honor, because the report was so deficient as to be a nullity here, it does not require preservation, and that was said by the Court of Appeals. Regarding the excessive sentence, Mr. Parker, as a first-time offender with an untreated and undiagnosed mental disorder, was excessively sentenced with 20 years, which is almost the maximum sentence here. He has strong prospects for rehabilitation.
This was a negotiated plea, right? So he agreed to the sentence, right?
Your Honor, this is a negotiated plea. However, the fact that it was a part of plea bargaining does not bar this court from using its powers.
We are talking about 9-year-old victims who were entrusted in his care, right?
Yes, Your Honor. And at the time, he was not aware that he had this mental disorder. He has demonstrated willingness to get treatment and a readiness to obtain a different career path after. So we would just ask that Mr. Parker's sentence be vacated and remanded, or alternatively for a sentence to be reduced. Thank you.
Thank you, counsel. Thank you both. Jeff Tang, LLC against Orchard Hospitality.
Thank you, Your Honor. Neil O'Marahu representing Orchard Hospitality, which is the majority and owner and managing member of Tangy Noodle, which is the LLC at issue in this case. In this dissolution proceeding, I submit to the court that the mistake that the IAS court made and what this court needs to do is make a more careful review of the terms of the LLC agreement. Right, there are two possible interpretations here. One is our interpretation, which is that the LLC agreement has Orchard as the sole manager, Orchard making all the decisions with advice and support from Chef Tang. Or there's the other interpretation, which is that Chef Tang is somehow a de facto, without ever using those words, a de facto co-manager, even though there's no support for that language other than some vague precatory language in the LLC agreement. So going through the LLC agreement, you know, we see, for example,
Well, another way to look at their interpretation is that they're thinking about brand Chef Tang. You know, they're branding an entity. You seem to take a different tack on the business purpose, that it was for a noodle shop, not necessarily associated with Chef Tang. Is that a fair assessment?
I think that Chef Tang was involved in the branding, certainly, but the question is whether Chef Tang has managing powers or is a member, not a member, but has a manager and has rights sufficient to prohibit a dissolution as opposed to being a mere member who has a right to bring an arbitration or some monetary claims for breach of fiduciary duty and breach of contract. And what we're seeing here is not that there are no monetary claims have been asserted. What we're saying here is that he doesn't have sufficient contract rights. His rights have not been violated sufficiently to require a dissolution of the LLC. So under the LLC agreement, business is defined as noodle restaurants to be directly or indirectly operated by the company, not Chef Tang noodle restaurants. Members' obligation on R20, which will become important later, is defined as the obligation of Tang as set forth in Section 4 of Exhibit A. Defaulting member, which is in R22, the definition of defaulting member gives if Chef Tang defaults in his member obligation, it doesn't say, oh, the purpose of the LLC can't be realized. It instead gives the manager the right to purchase his interests. The next most important provision is management authority, which is in R25, which gives my client the right to carry out all acts and affairs of the business, and then which are not otherwise prohibited under this agreement, so that they must be prohibited from doing what it is they were doing. It also gives my client the right, because they control the majority of the membership interest, to materially change the nature of the company's business. If their argument is correct, of course, then this power is illusory. And it also says that members have no management power except as expressly provided in the LLC agreement. Then if we turn to Exhibit A, which is where the Chef Tang says they get their powers from, Section 4 says, and they say that Section 4 essentially lists a series of rights they have, including develop the general menus, but that's not an explicit right. It doesn't expressly say that they have the right, the sole right to develop the menus. It doesn't say that, it doesn't expressly prohibit it doesn't expressly prohibit my client from changing the menus. And then Section 4.3 says that they provide training to all kitchen employees and coaching and advice, but again, it doesn't expressly prohibit my client from giving coaching, giving training, and it doesn't give...
So what about Section 5.1, which says that all of this will be heavily relied on and contingent upon Chef Tang's expertise, skills, experience, knowledge, know-how, goodwill?
Well, that's exactly the next thing I was getting to, Your Honor. This is Section 5.1. Now, Section 5.1 is interesting because it's purely precatory. It doesn't create any right or duty by any party. All it does is give background information. And we submit that what it gives the background information explanation to is Section 5.2. And what Section 5.2 does is it explains why Mr. Tang personally has to sign the agreement, right? The members of the LLC are Chef Tang and Orchard, but really the person that's surprised to provide these services, who has to perform these obligations, not rights, but obligations under A4,
But,
He's-
but
Mr.
under
Tang.
5.2 that you just referenced, it indicates that given Tang's personal involvement is critical and fundamental to the arrangement under this agreement.
It says, and because of that, Tang shall maintain no less than 70% ownership interest in Chef Tang LLC. It's an explanation for why he has a duty and an obligation, and an explanation why he has to do it himself, not a power for him to veto management decisions by Orchard.
Thank you, counsel. You have time in rebuttal. Did you want to say anything more?
May it please the court, Jeffrey Wilson, Wilson and Chan on behalf of Appellate Chef Tang LLC. One point that often gets missed is that Chef Tang LLC is wholly owned by a person named Chef Chen-Li Tang. He's a renowned chef in this city. He's the son of a very famous chef. And the reason that there is a tangy noodle is because of Chef Tang. His reason for being here is the 70 years he's been learning how to cook Chinese food. It's because his restaurant.
Counsel, there's allegations that possibly create issues of triable fact. Tell me I'm wrong, concerning Chef Tang's noncompliance with his duties with respect to the restaurant, and that he torpedoed the LLC by inactivity, and his own actions or inactions.
Okay.
You know, doesn't that give rise to at least to a hearing concerning whether or not there should be dissolution if he behaved in that way? If he behaved in that way, and I'm not saying he did.
Well, we certainly would not concur that he behaved in that way. In fact, what he did.
Okay, just, you know, take it on as a hypothetical.
He did a lease, fixtures, his entire story for the marketing of this campaign. He supervised the kitchen. They simply didn't like the way he supervised the kitchen staff. And so they told him in no uncertain terms, don't come back. So the real issue here is not, there's only one fact that is operative in our opinion, and that is whether or not Chef Tang is involved in this LLC. And if not, can the purpose of this LLC go forward? Can this LLC go forward without him?
But what is the legal standard under the limited liability law? I'm sorry, limited liability company law, 702.
702 says that would not be reasonably practicable to carry on the business in conformity with the Articles of Organization. So that is the standard. Now that has been addressed by various courts about what not reasonably practicable means. Some have said unable to function as intended was one. The management has become so dysfunctional or its business purpose so thwarted that it is not reasonably practical to continue, or discord and disputes shown to be inimical to achieving the purpose of
And the purpose here was a noodle shop, not,
The purpose here was a noodle shop serving food designed by Chef Tang that was going to have his name on it.
Is that how the purpose of Tangy Noodle was articulated?
Of course it was. I love the description of Exhibit A here. But Exhibit A, the very first part of it says anything that's in Exhibit A supersedes anything else in this agreement. And Exhibit A is very clear. They made him sign it because they wanted his participation. They made him sign it because his personal involvement is critical and fundamental to this business.
Well, it
if he
could
had
be
died-
fundamental from a branding standpoint, but not fundamental from the overall purpose of the business, which is to have a noodle shop.
A noodle shop which serves his famous noodles, without which there is no noodle shop, without which you get what you have now, which is just another Chinese restaurant that's not serving Chef Tang's food.
But then why, if it was so critical and so integral, wasn't Chef Tang referred to in Section 2.4 where the purposes of the company are set forth?
Yes.
Because there was only two members here, one of which was entirely necessary. It was the basis on which this business was going to be founded, and the purpose, they were operating a noodle shop together. One brought skill and expertise, one brought ambition and money.
But when it's defined, when the business is defined, it doesn't define it as you've just defined it, which is a noodle shop with the recipes from Chef Tang.
Well, that's why it can't be, that can't simply be plucked out of this agreement, because this agreement, the entirety of this agreement states the parties' intentions, and the Exhibit A is critical in that. In fact, to the extent
The
that
definition of what the business is not listing anything relating to Chef Tang.
well, it requires his personal involvement, which means, and to the extent that Exhibit A differs from the original, or the purpose, Exhibit A controls. That's what the parties agreed. That was what they understood. There is no tangy noodle without Chef Tang.
Thank you, counsel.
Thank you, Your Honor. Quickly, before I respond to the arguments, I want to agree with the court that there is an issue of fact about who caused the dissolution that the court below mistakenly not overlooked, but didn't resolve correctly. This proceeding is in effect a summary judgment-esque proceeding that a dispute of fact has been raised about as to whose fault it is, and we've cited cases showing that under those situations, this is essentially an equitable remedy. Inequitable conduct by the party seeking dissolution is a grounds to deny dissolution. I also refer the court to the arguments in my brief about the injunctive relief, which I'm not going to get into now, but is very overbroad, especially as against my client as against Tang.
You'd concede that there was some injunctive relief sought in the petition, however, correct? It was
right.
there.
Right.
Yeah.
But it wasn't argued until reply, and there's just no legal basis whatsoever to give injunctive relief against my client, prohibiting it from doing business.
What about the use of Chef Tang's history and
I understand, Your Honor. My response to that is to say that there's one fact that's important in this case, and that's what's written in the LLC agreement. That's how these cases are supposed to be decided. I think the court correctly identified this issue about what the purpose of the restaurant is.
So I'm sorry to cut you off, but so do we give the stated purpose in the agreement primacy over all of the other provisions of the contract or the agreement? Because clearly Chef Tang was important to the business and to the model for the business. But in deciding whether dissolution is appropriate under the limited liability company law, do we look only to the stated purpose?
I think that the stated purpose should be given primacy. I also refer the court to the other sections that I mentioned. Orchard's right to manage unless explicitly prohibit, Orchard's right to change the purpose of the business if it saw fit in its sole discretion, and the fact that Exhibit A, Section 4, which they rely on to say, well, these are the rights of Chef Tang, are actually just duties. They don't give them rights. They don't give them sole rights, and it doesn't allow Chef Tang to override any decisions that the manager makes. Thank you.
Thank you, counsel. Thank you both.
Any from you, Your Honor?
No, I just was thanking you, and thank you both.
Thank you, Your Honor.
So the next case is People versus Rosa, and Justice Michael is recused.
May it please the court, Desiree Sheridan, the Legal Aid Society for Appellant Michael Rosa. I really wanted to address the appeal waiver in this case, which I submit was not knowing, intelligent, and voluntary. Here, the plea minutes show, on page 6 of the plea minutes, that the appellant or defendant agreed to the appeal waiver before the conditions of the waiver were ever explained to him. So in that scenario, he couldn't possibly have agreed to a waiver that he knew nothing about. So for that reason, I submit that the waiver itself was not effective, despite the fact that the court later explains the waiver because he did make this agreement on page 6 of the plea to waive his right to appeal before being told what that encompassed, before necessarily understanding what that meant, that the later explanation is in essence irrelevant. And I would actually kind of apply like a cat out of a bag analysis that is commonly used like in terms of, like attenuation with statements. So I would submit that in this case, because in the very beginning of the plea proceedings, he's asked if he's waiving his right to appeal, and he says yes, but he never was told what that meant. So later on in the proceedings, even though it gets explained to him, he may very well have thought, well, I already said yes, in the beginning of the proceeding, I have to stick with this agreement to waive my right to appeal. So I would argue, because of the scenario in which this happened, that anything later is really inconsequential, and the waiver is not knowing, intelligent,
So
voluntary.
let's move on to the merits about whether the sentence is excessive or not.
Yeah, well, I mean, I would still argue that I would argue that you can reach that issue, and that, here I would argue that the sentence was excessive. He could have received a sentence of 3 years, and instead he received 4 years.
Also, I guess the worst would have been 15 years in the top count, right?
That would have been, yes.
It was his second felony conviction. He had an open warrant in Pennsylvania for shoplifting.
Yes, but you wouldn't even be able to reach those if you found his waiver effective. So preliminarily, I would argue that his waiver of appeal should not be considered effective so that you can reach the sentencing issue. And so that's why my concern is with the waiver, and why I think it's not a knowing, intelligent, voluntary waiver in these circumstances, so that you can get to the sentence issue. And if there are no further questions, I will rest on my brief.
Thank you.
Thank you. Good afternoon. May it please the court. First, turning to the issue of the waiver, the defendant did validly waive his right to appeal in this case, although the court did engage in its colloquy after the defendant signed the waiver. This came in the full context of the plea hearing, after the court asked the defendant whether he had read and understood the waiver prior to the hearing, and whether he had discussed as much with his counsel prior to the plea hearing.
Is there any requirement that it be signed after the colloquy? Any requirement that it be signed after?
There's no requirement to that effect, Your Honor. The requirement is that the defendant understands the rights that he is waiving, and that's taken holistically in light of the entire hearing. And further, the waiver itself, of course, supplements the oral colloquy that was given by the court in that case. And then to move to the merits of the excessive sentence, if this court does find that the waiver was invalid, the sentence in this case was not excessive. It was under the minimum that the defendant was facing if he would have went to trial, which he was facing a charge of second-degree criminal possession of a weapon, which came with a minimum of 5-year incarceration and a maximum of 15, as Your Honor mentioned. And the negotiated plea in this case was for the defendant to receive 4 years incarceration with 5 years post-release supervision. Again, under the minimum that he could have faced if he went to trial. And the people's evidence in this case was strong. The defendant made multiple admissions. And unless there's any further questions, I would rest on the brief.
Thank you, counsel.
I just wanted to briefly also go back to say another reason why the waiver should not be considered valid is because he did sign that waiver before it was ever explained to him. So here he's signed the waiver, he's verbally agreed to it in the beginning of the plea proceedings. So by the time and also the court, I think, also used some mandatory sounding language telling him that people were requiring the waiver. So by the time the waiver does finally get explained, I think that all of these factors culminated to make him think, even if I didn't want to agree to the waiver, I have no choice but to agree to the waiver now. So I would find that as yet another reason why this waiver should not be considered valid. And if there are no further questions, I rest on my brief.
Thank you very much, counsel. Thank you both.